All right, so we want to start this podcast off with a weird question. And that question is, do you have the right in this country to die? And the way that's framed is kind of weird. It's kind of counterintuitive because, like, what do you mean the right to die? I mean, doesn't that just happen to you? So it's like the government saying you don't have the right to die. You must exist forever. That's not really what we're saying. What we're saying is, do you have the right to physician-assisted suicide?
That's right. And hey, good morning, Brenton. Thanks for having me on. I think we're going to have a great discussion lined up for our listeners when we're talking about physicians-assisted suicide and how that mixes in with the right to live versus the right to die, and where that's bound up in the Constitution. What sort of things would come into play if we're talking about the United States Constitution and how there might be some sort of fundamental liberty at stake, right? And any sort of Supreme Court cases that have examined this particular issue. There's been several, and where they might be finding some sort of foundation, some sort of legal source to say, hey, maybe this was something that's protected by the Equal Protection Clause in the Constitution. Maybe it's something that's contemplated by the due process, by due process, which is found in multiple amendments to the Constitution.
Right. So let's talk about that. So let's say a state has, which for example, Oregon has this a right to die law that says you have the ability at a certain stage of a terminal illness, if it's contemplated that you have 6 months to live, then you can receive a lethal dose of medication to assist you in dying before you get to the terminal stages, or I guess the bad part of the terminal stages where it's just suffering. And so what's contemplated is that there's a compelling interest to allow you to end your own life, and because what you're trying to prevent is human suffering. So let's assume that there's states that have that and there's states that don't have that have a ban on physicians giving individuals a lethal dose to end their suffering in terminal stages. So it's important to kind of sparse that out a little bit, because what we're talking about here is not just general suicide. We're not talking about someone who's healthy and otherwise would live for an indefinite amount of time. We're talking about terminal illness and lack of suffering here, trying to end suffering. And if you want to put that in the context of the fundamental rights legislation or fundamental rights jurisprudence, what you got to think about is, okay, well, how are fundamental rights treated? How are rights treated generally, right? So you have a category of rights that are considered to be fundamental rights, okay? So if you're talking about the due process clause of the Constitution, right, of the 14th Amendment of the Constitution, due process clause is essentially protecting these fundamental rights. So these fundamental rights can't be violated by the government without some compelling government interest, and that whatever action by the government has to be narrowly tailored to that compelling government interest. And that's what we call the strict scrutiny that the court uses to make sure that whatever action that is infringing upon what we consider to be a fundamental right is proper, is good to go. It fits into that category. Okay, so these fundamental rights, are things like, the right to free speech, right? The rights that you would traditionally imagine are protected.
Exactly. You just said the magic word, Brenton. When you're talking about how to identify a fundamental right, okay, what does that mean, right? As opposed to other rights, right? The Supreme Court has given specific language, or at least looks at that, analyzes that through a specific lens where they're looking to see whether that particular right is deeply rooted in our nation's history and tradition.
Right, which is a weird way to kind of look at it. You think fundamental rights are fundamental rights, things that are not necessarily deeply rooted, but but are considered to be something fundamental to human nature, to human rights. So, that's kind of the argument with the right to die. There traditionally hasn't been the right to die in the United States. It's not deeply rooted within our history and culture and our laws.
That's exactly right. That's what, there's a case, I think you had put me onto this, Washington v. Glucksberg. That was a Supreme Court case where they're looking at physicians-assisted suicide through the lens of due process. Does this violate the due process clause? I think it was it Oregon or New York? One of those two. Or no, it was Washington State. Excuse me, Washington, obviously. So Washington prohibited physicians-assisted suicide, right? And they had a law against it. And basically, what they did was they said when they're reviewing this, they go through and they say, okay, well, is this something that's traditionally rooted in the nation's history? And they look back, and in their opinion, the Supreme Court opinion, they basically said no, because there have been continuous efforts throughout, the history that we can examine to prevent assisted suicide. Therefore, it's not part of our tradition, right? But they actually left open, if you read further, they actually left open the debate about that when they talk about how, hey, look, there is this ongoing, debate about morality, legality, and even the practicality of physicians.
So when I read that case in law school, I was like, this is bullshit. How do you know it's not deeply rooted within what kind of study was done? They didn't cite any of the study that had been done. How do you know it's not deeply rooted? I can guarantee you that there has been, a deep tradition of ending suffering in the United States, both with, humans and animals. I don't think animals is a good, analogy, but I mean, the idea, it's a basic human instinct to want to end suffering. And if the person desires to end suffering at the terminal stages, then yes. I mean, you can't tell me that there hasn't been physicians over the years that have given people lethal doses of things like morphine ever since opiates have existed as a medication in this country. You can't tell me that hasn't happened, and things hasn't happened.
I think what you're getting at is
we just don't talk about it. It's just that hasn't been accepted as a common practice. That doesn't mean it's not deeply rooted as a tradition.
Sure, and obviously reasonable people can disagree, right? I consider you a reasonable person, but reasonable people can disagree, and that's part of the reason why we have the institutions that we have, like the Supreme Court and all of the sort of filters all the way up, right? But it's not a perfect system. It's not.
Yeah, and it's not that I'm necessarily saying that physicians-assisted suicide is something that should be protected as a fundamental right. But I just think that it's a cop-out based on the analysis and logic and rationale used in the Glucksberg case. Because I just don't think you can offhand say, oh, this is not a tradition, and so therefore it's not a fundamental right. If that's the basis that you're using for what we consider a fundamental right.
Well, I think that I would agree with you. Again, I think your argument hinges on this disagreement as to the nature of the right, whether it's fundamental, right? But since the Supreme Court said ultimately that it wasn't, basically all they had to do was show that it was rational related, right? So the different levels of the scrutiny that the Supreme Court has developed over decades to examine something to decide what level of scrutiny they're going to apply. At this point, if they can identify that it's not a fundamental right, that would fall into the strict scrutiny category, right? Required a narrowly tailored legislation. Then really it comes down to whether at this point it's rationally related to some sort of government interest, right? Legitimate government interest. And I believe, Washington, that opinion out of Washington actually goes over some of the things that it relates to as to how the ban was inconsistent with several government interests.
Yeah, I think that the government interest in banning assisted suicide is, maintaining the integrity of, the medical profession, sure. Not putting people in that position where they're doing that, preventing possible, misdiagnosis and then suicide after misdiagnosis, things like that, which I think that maybe that's certainly a rational basis, maybe not a compelling interest if it were considered to be a fundamental right. And that does beg the question, because really what the court is saying is that, okay, each state has the ability to say, okay, you don't have the right to die, as long as there's a rational basis for that law. So that results in one state like Oregon saying, well, we think you have the right to die. And then a state like New York saying, well, I don't think you have the right to die. And because we think that there is a rational basis for preventing that from happening. So that resulted in another Supreme Court case, which I believe is Quill. And that one was the equal protection challenge. So equal protection, what's that all about?
Yeah, I mean, equal protection is the first section. It's the first section of the 14th Amendment, right? Which basically says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process, nor deny to any person within its jurisdiction the equal protection of the laws, right? So that first part, when they're talking about we shall not abridge the privileges or immunities of the citizens of the United States, ultimately, that's the express language, okay? But ultimately what that means as a general rule is that states must treat the same situation the same, right? Like situations must be treated alike. Whereas dissimilar or situations that are distinct from another can be treated differently.
Yeah. So you have the privilege and immunities clause there, and then you have the rest of the equal protection clause of the 14th Amendment that basically is, you're exactly right. It's saying that the states have the ability, hey, if the same situation, you can't treat it differently. Okay. So you need to have consistency because we have these things called, basically we have these different states, which are different sovereignties. So we don't want them to treat people differently because then we're not the United States, we're a bunch of little countries all together. So that's the rationale behind that amendment. And so what the claim in this case is okay, well, how can one state allow for a right to die and the other state not allow for it? What is the basis for that? What was the claim, and what is the response to that?
Sure. So basically, this is a case called, I think it's Vaco and Quill, and Supreme Court case basically surrounding a law out of New York that banned physicians-assisted suicide. And ultimately, what the court held was that was okay. And that law did not violate the Equal Protection Clause of the United States, right? Because the court distinguished between two things. They distinguished between letting someone die versus making them die, okay? Versus basically inaction or some sort of passive setting versus some sort of affirmative action towards that relates to someone's death. And so they distinguish those things. And so
right, which is obviously a very different thing.
Exactly. So we're not even talking about due process at the point. They're looking at it through the lens of the Equal Protection Clause, right? What we just talked about. And they're saying, hey, look, are these the same? Is this the same situation? If not, then they can be treated differently. And these laws can be basically up to the states.
Right. So the answer is it's not a violation of the Equal Protection Clause for some states to ban the right to die, and it is not a violation of due process to ban the right to die. So of the two, really, I think the sticking point that I've always thought, where the right to die could eventually become something that cannot be banned is under the Due Process Clause. That's where I think it fits way better. I think
Sure.
the Equal Protection Clause just doesn't really quite. I think that was a shot in the dark, and I think the lower
And the alternative, Your Honor.
Yeah, and I think the lower appellate court really just kind of was winging it on that one, fast and loose with that decision. So the Supreme Court was right to overturn that decision in the Baco versus Quill case. But, you know, I still have an issue with the analysis of whether or not, you know, you have the right to die as a fundamental right. If we take out this whole somewhat arbitrary analysis to consider what is and what isn't a fundamental right as something that's been historically, rooted in this country's culture. I mean, should we do a sociological analysis on every time we want to consider whether something is a fundamental right? I mean, wouldn't it require historical and sociological analysis, or that's independent that the court has to rely upon, or is it just the court's view of what the history and culture is?
Yeah, and I mean, I think those are great questions, and that ultimately goes back to, you know, the fact that we have these institutions, we have this process, but it's not perfect, and we have people, fallible individuals that are ultimately, you know, vested with the authority to make the call at the end of the day. And you want to rely on that decision as being something grounded in reason and logic, and morality as well.
Because here's my point. So you have this idea of precedent and stare decisis. So we know what other cases have said. So if the court is saying, hey, we are bound by the decision of prior decisions of this court, okay? And so we're basing this new decision on what a right is, this classification. We're basing this new, decision that we're making here off of prior decisions, and our hands are tied unless we can find a really good reason to differ. You know, they have that self-limiting check on how they decide new cases. So for example, if they're going to decide a case on freedom of speech, they can't just pull something out and say, okay, well, this is what we consider to be a violation or not. They have to go based on prior decisions that the court has made. And that's a limitation that the court has placed on itself, rightly so. But here's the thing. If you're basing something off of what you consider to be historically rooted in this country, then there is no precedent that ties your hands, right? I mean, you can look at like other court cases, but beyond that, if you're just saying, oh, well, I don't think that traditionally doctors have wanted to do this and blah, blah. I mean, how do you know that? How do you know that? And should the court attempt to do the same thing when they start to go kind of on that caveat? They start to go kind of on that, that side road. Can't think of a better term for it, where they're doing a very similar analysis to like precedent and stare decisis, but really there is no basis for it. There's no historical data or anything that they provide to say, hey, this is what is making this decision.
If that's your position, if you basically what you're saying is the absence of data should not hinder them in creating a fundamental right. But I would say the opposite, that in the absence of data, we're not going to claim that this is a fundamental right unless you can show that this is something that is pervasive and is something that is, consistent. And that obviously wasn't done, which is why they didn't want to make it a fundamental right. Because they're not, I think that the time and history shows that the justices are more reserved to, they're less inclined to create rights.
Well, I think we're both identifying the same issue. We're just saying the opposite thing. So right. but the issue stays the same. There is a lack of data. So you're saying that, okay, this is how you err on this side if there's a lack of data. I'm saying maybe you err on this side if there's a lack of data. I'm saying maybe you err on the side of giving people more rights.
I think that, but the court's not giving rights here, right?
But here's the thing about that. The question still stands. If it's the court's job to interpret the law, and they're interpreting the law based on what they consider to be historical or cultural or whatever, is it their duty to determine what that is based on some type of data? So have a data-driven determination based on some type of study or whatever, or a number of studies that they themselves employ.
I think that there's certainly some due diligence involved there with respect to their own, analysis. But I think that
where you don't have a data-driven
any other court, they're going to look at what's presented to them, right? So I mean, we obviously don't know all of the information that was provided and reviewed during that, in the process that led up to those decisions. And if there's an absence of that, then I'd say that that's something that, I mean, it's a done deal, right? Until it becomes an issue again that's presented, and then they can look at whatever data is presented at that time.
Yeah.
But in the absence of data, I would be more reserved to create and express fundamental liberty, or identify a fundamental liberty that I think that, and it's not an exact science, obviously. The terms deeply rooted in a nation's history and tradition is rather vague and potentially, an arguable point. Obviously, we're having a little bit of a debate about it now, but ultimately, you want to. I think you're erring on the side of, hey, look, basically what it resulted in, what these decisions resulted in, is saying, hey, the Constitution doesn't say one way or the other if this is whether it's okay or not, right? They're saying that, hey, look, this is something that we can leave to the states to decide. That the Constitution doesn't determine the outcome, which I think is, if you're looking at it, probably the best outcome, because we're leaving it up to the individual states to decide. And there is a bucket of rights that traditionally the states hold, right? So you're talking about whether the states have the right to permit or ban physicians-assisted suicide. What other rights have states traditionally been able to, or been left to the states?
Yeah, well, the police power, the ability to keep people from killing each other.
Sure.
Or killing themselves.
That's right. The idea of the preservation of life, right?
Yeah. Yeah, certainly.
Sure.
And you could certainly claim that, you have a competing interest here. The state's police power is a competing interest against the federal government banning, allowing, assisted suicide. I think one of the things that come up, though, beyond that is, okay, well, if you leave it up to the states, let's say we have, it's the same kind of argument you have with the legalization of marijuana, which is not necessarily left up to the states. It's just, the Fed has kicked the can down the road on that. We'll talk about that sometime. But anyway, so it's a very similar concept where if I can't die in North Carolina, then I'm just going to drive to Oregon so that I can, meet Dr. Kevorkian and, he can help me out, right? Or if I can't get high legally in North Carolina, then I'm going to drive on over to Colorado, where I can get a mile high.
I can't buy fireworks in North Carolina. I got to go to South Carolina to buy them.
Yeah, exactly. Exactly. Fireworks are a little bit different, but
yeah, maybe.
I mean, you might die with fireworks too.
That's true.
But I think that's one of the, arguments there is like, okay, well, the people are still going to do it. You're just making it inconvenient.
Right. But I think that goes back to, ultimately, the door was left open, right, with this topic, as to say, hey, look, we get it. We don't think that based on the information we've been presented that there is enough to say this is a fundamental right, but the conversation's ongoing, right? There's a debate going on about the morality of this, whether it's legal, whether it's practical for a physician to engage in that, and that debate continues. Obviously, we're talking about it today, and I know that we're probably not the only ones.
Right. So, okay. Here's my question. You ready to get controversial?
Okay.
All right. So, abortion. So you don't have, yeah, I went there. You don't have a fundamental right to abortion, by the way. It's a weird, made up level of scrutiny. I'm just going to be real with you. They made up a level.
Isn't it all made up though?
It is all made up, but traditionally we've had a couple like levels of scrutiny that we've always had. If you want to talk tradition, we've only had the three. We've only had rational basis, intermediate, and strict scrutiny. Okay, so then you have the one for abortion, which I forget exactly what it's called. It's like it's like intermediate scrutiny plus one or whatever. It's like somehow in between. Strict scrutiny and intermediate scrutiny. So basically they said that, hey, this is not a fundamental right, but we're going to treat it like it's a fundamental right.
Right.
Okay. And so, and it's an incredibly interesting, part of the jurisprudence in general, and not taking a stance on it either way, but I just think it's very interesting how the court decided that they wanted to legalize abortion and not just legalize it, but they didn't want states to ban it. But they still didn't find that it was a fundamental right. And by the way, guess what's not rooted in our tradition, history, or culture?
Right. Which is why it's not an express fundamental right. But I think what you're talking about.
But by the way though, but is it number one express fundamental right? I bet it is. But you're just calling it something else.
It's difficult, even if you read through those cases, Casey and all the rest, right?
Yeah.
Then I think it still leaves a lot of folks, even legal scholars, confused as to exactly what they're getting at. And I think that I identified this when I was reading through these in con law back years ago, where I'm like, man, this seems to be this tendency, and I don't speak, and I say this in the most respectful way, but there seems to be this tendency where there's a willingness to play some mental gymnastics to get to the outcome that you want. Right? Yeah. And that's it. I mean, I think that's just a symptom of a display of, the fallibility of mankind, right? I mean, we are fallible creatures.
Well, because okay, with the abortion jurisprudence, what you see is, okay, let me just go back to the point I was going to make about it being rooted in history and all that. Okay, abortion is rooted in history and the culture of this country. It's just like assisted suicide. No one talked about it, but it happened all the time. There just wasn't places where you could go that was sanctioned by the government to allow it to happen, but it happened. It absolutely did happen. And so that's the thing, is like, how are we going to treat one thing it's a very, very similar thing.
But because it happened, I'd push back a little bit. Just because it happened doesn't mean it's pervasive or that it's deeply rooted in the history and tradition. As in to say that,
I think if you look at the sociological studies, you would see that abortion has been a part of this country for a very long time, ubiquitously, whether or not it was legal.
It's been a part of human existence. Yes. I mean, regardless of whether it's been, notwithstanding any legality, right? It's been happening since recorded history, right?
Yeah.
And I'd say probably the same as, similar to the topic we're talking about now, but I think that, there is this sort of societal pressure or notion, or even an express disagreement in the positions that people take as to whether that should be allowed from a moral or legal perspective, right? And
which I think is incredibly odd. I think with the argument to, like, if we're going to use a corollary, that's the word I was trying to search for before, by the way. We're going to use a corollary and say, okay, abortion is kind of the corollary to this argument for the right to die. Well, if you're talking about the right to your own body, right? The right of you think it'd be the most fundamental right ever, the right to exist or not.
To bodily autonomy?
Yeah, and whether or not, you exist after you die is a metaphysical argument. We can get into that too, but the right to exist or not, it should be the most fundamental right you have.
Sure.
It makes no sense to call that anything but a fundamental right. And you're telling me that someone can make the argument that have a right to their own body and then have have an abortion, which I'm not taking a stance on it, but someone who is suffering and is in the terminal stages. I mean, if you've ever witnessed or been around someone with cancer in the terminal stages of cancer and the suffering that they go through, it's incredible. And the thing is too, is most of the time they're so doped up on medication that they don't even know they exist. And it's just suffering. That's all it is. And we're trying to end suffering. And you're telling me that that person doesn't have a right to do that. And that's not a fundamental right that shouldn't be infringed upon unless it's a damn good reason. That's just crazy to me. If you just take the logical argument too, if you just take the all the bullshit about scrutiny or whatever out of it, and you just look at it logically, what it looks like is exactly what you're saying. We're playing mental gymnastics to get to the decision that we want.
Mm-hmm. I think that is a common theme. Okay, based on my reading, and I think that again, it's not going to be perfect. People are not perfect, and some decisions should probably be changed. Some decisions should have never happened. But everybody's that's the purpose here is to talk about these sorts of things.
Right.
If you want to look at the value here, the value is being able to examine these types of situations, see how they got there, use critical thinking to evaluate the approach and look at the conclusion, work your way backwards and work your way forwards again, and just see how do we get there? Is it consistent across the board? If not, what are ways that we can improve?
Right.
As a society, right? In our institutions, how can they be better?
Yeah, and I think as estate planning and other law attorneys, this is something near and dear to our hearts about this end of life suffering, end of life situations, and really the way that I look at it as so I see it from this point. You have guardianships which can deprive people of all of their rights. People can be sterilized under a guardianship. You can move the court to approve sterilization under a guardianship. And this rights can be taken away from people in such fundamental ways. And as you age, as you lose cognitive ability, but it seems a little bit one-sided, where the older you get, the more you get to possibly experience terminal stages, the less rights you have. Because the more you get towards terminal stages, I mean, a lot of people in this country have pre-Alzheimer's or Alzheimer's. And so a lot of people who are living right now and are functioning fine right now are going to end up having some type of Alzheimer's dementia, which is a terminal diagnosis and can lead to suffering at the end of life. And the thing is that, the question is that how do we approach that? How do we approach, because the country is aging, we have more old people than ever, right? And it's going to be that way for a while. And so how do we approach these hard questions about how we prevent suffering? I mean, in a guardianship, you can sterilize somebody. Can you allow someone to end their suffering? I mean, these are important questions to broach once again. I mean,
I don't think you're going to eliminate suffering. I think it's a lofty goal to pursue to mitigate or to ultimately eliminate if that's the effort. But I think that much of life is suffering for a lot of folks, and at this period of time in history, in this country, we've minimized that to a degree never having been seen before, right? But we have to look at it's not this. I don't think it's as quick as it's liken it to the same argument as the abortion policies where bodily autonomy. It's my body. I should be able to decide, right? I mean, I think that there is a compelling interest, right, and government interest, if you will, right. And when we talk about government, it's not us versus them, but in government, as in like we have collectively agreed that there is an interest in preserving life. There's an interest in protecting vulnerable people from psychological or financial pressure to end their lives, right? To avoid euthanasia and so on and so forth. There are all sorts of reasons why maybe we shouldn't just open the doors wide open to allow that to happen, right? And similarly with abortion.
Well, ostensibly, you know, what we're doing here is, I think though that's kind of apples and oranges a bit. You know, there is a compelling interest for preservation of life, and in that, typically, what that means is a preservation of life based on, you know, outside force ending someone's life involuntarily.
Agreed.
So the preservation of life that we're talking about is someone else ending your life and you don't want it to be ended because
Agreed.
you want to survive. But that's a very different thing than saying, I want to die right now and I can't. You know, and the thing is too, is these people who want to end their life with physician assisted suicide tend to not be suicidal individuals who are depressed and wanting to end their lives because of some overwhelming emotional event, right? So a lot of those are acute and events and not necessarily chronic things, right? Certainly there's chronic depression that can lead to suicide, but I think if you look at the studies, the majority of suicides are based on an acute event. So one, you know, event that, like, whether it's a loss of a loved one, loss of a relationship, loss of a job, something like that, that can lead to, you know, someone being in such despair that they decide to take their life. Now, chronic, you know, depression exists too, like I said, but that's not necessarily the thing that leads to suicide most of the time. And these individuals are coherent, they're rational, they're competent. They just want to avoid not just a suffering in general, but a certain very, very specific type of suffering.
I wouldn't pretend to ascribe a specific reason that is you know, a majority reason for why people commit suicide. I think oftentimes you just never know. You know, you've talked about an acute event. Sure, I mean, one thing happens that leads to another. It could be a lifelong, you know, series of painful events or lifelong depression or any other mental disorder, right? I mean,
yeah, you don't know what led up to, you know, that might be the straw that broke the camel's back. Sure.
Yeah, I mean, I think ultimately I would think too that, you know, I've always thought of, just from a personal perspective, a physician as a healer. They're a healer. I mean, that's I would venture to say that that's likely why most of them got into it.
Yeah, but I think that the physicians that would administer, you know, the medication to help someone die would see themselves still as a healer.
Sure. That and that's I mean, I can't necessarily,
like amputating a leg in a way, you know. I mean, you took a Hippocratic oath that says first do no harm, but that doesn't mean that you can't take off a leg to save somebody from ostensibly, you know, death or suffering, right? So I think those are kind of, they can be one and the same. What quality? I think you have to look at what quality of life and the inevitability of the death too. I mean, these are terminal people. You can't heal them.
And again, that's the distinction that was made in Vaco, right? The distinction was, hey, are we okay with taking affirmative steps, or are we okay with, you know, passively removing things that would prolong suffering?
Exactly. If you want to get in a metaphysical debate about it, I mean, what is the difference?
Yeah. Well, I mean, if you are not doing something to sustain a life, is that the same as doing something to end a life? And I think the court has been clear and said, no, that's not the same. That's why it did not violate equal protection.
Yeah, and I think metaphysically, though, there's an argument that, like, if you compress the time, I mean, if you have 6 months to live and you decide to end it in month 3, you know, what are you really losing there? Yeah. You know, I know you had to take an affirmative action to take that life, but what are you really losing there? I mean, what is 3 months of suffering gone? You know, is that really, do we really have such a compelling interest in preservation of life to keep somebody alive for 3 months? You know?
I don't know. I think we come back to, you know, some of the things that as a society, as people, we value versus, you know, this idea that it should be up to us as individuals, right? And it should be allowed, permitted for others to assist in that regard. I mean, these are not easy questions to answer. These are not, you know, they involve all kinds of different values and morals, and you know, people come from all walks of life and perspectives, and have the very different experiences, and probably gone through it themselves and feel strongly about this, right? Very passionate about the positions that they hold. So I think when you're talking about these things, the biggest and the best thing to do is just be respectful of others and their position. But you want to look at it in a critical way, and employ critical thinking to get down to the issues, right? To the legal issues, and beyond that, what really should be the law? What should the law support?
Yeah, exactly. And really, whether or not we should err on the side of individuals being able to make that choice for them, because you're right, they all come from different walks of life. I myself might be adverse to wanting to take my life and might want to squeeze out everything I can out of this life, right? Whereas someone else might want to say, hey, I know when it's done, it's done. I want to just enjoy, what I had and not go through the rest. Those are interesting questions, and certainly an interesting discussion. I really, I think this podcast in a lot of ways is my opportunity to revisit some of the law school arguments that I didn't get to hammer out as much as I wanted to, because I didn't want to be shunned in my law school classes.
Sure.
Right? But I think that these are important things to think through and talk about, because these are the things that matter. I mean, going forward, we have to define what our rights are and what they should be, and what the morals and values of this country are as they adapt. So I predict that there's a possibility of seeing more of a right to die in this country, just because of where the debate's going right now.
Right.
However, if you have an opinion on it, we would love to hear. So if you heard this and it is something that you have strong feelings on, whether it's right to die, I mean, heck, I'll even take your position on marijuana and abortion too. Leave a comment and or leave a question. I'd be more than happy to talk about any topics that y'all have questions about, or that you just want to say, hey, look how wrong you are about this. You welcome that too.
That's right.
So,
love that. And I'd say, hey, that's a good sneak peek into the next week's episode, possibly dealing with either abortion and or possibly marijuana use and legality there.
Yeah, let's just do abortion and marijuana at the same time. We can abortion, religion, and marijuana.
Yeah, it could be the most controversial episode ever.
That's right. That's right. Two guys talking about abortion. Whatever, we're gonna do it.
Sounds good. Thanks for your time today, man. I enjoyed it as always.
All right. See you.
Take care.